The chokehold death of 30-year-old Jordan Neely while on an F train continues to spark protests all across the city. Another protest took place yesterday afternoon on the Upper East Side. Protesters calling for those responsible to be held accountable.
And the medical examiner later ruled Neely's death a homicide caused by compression to his neck. The Manhattan District Attorney's Office still investigating here. So joining us now to discuss this further is defense attorney and former Manhattan Assistant District Attorney Jeremy Saland and Beth Harulis, the Director of Disability Justice Litigation for the New York Civil Liberties Union. Jeremy, why don't we start with you? A lot of people have been looking at this video. What are your takeaways? Again, the Manhattan DA has a difficult task on its hands because everybody keeps wondering, can they prove intent here? What kind of charges could they possibly bring?
Well, there's that natural instinct to want some justice, whatever that means, and it can mean different things to different people. But the DA's job is to figure out what, if any, is the right charges. And I would start from the top charge, which is a murder, which is murder in the second degree, which is an intentional crime. I really don't see that from the evidence that I know or that I've heard of, that is a likely choice. But what could be presented is something like manslaughter in the second degree or criminally negligent homicide. These don't require that intent. They require more of a recklessness and a carelessness and a disregard. So very different crimes, different standards, different elements.
Beth, what troubles you the most when you look at that video and you hear about everything that happened surrounding all this?
Well, I think the most disturbing thing is that a person on the train felt empowered to take into his own hands judge, jury, and executioner when it comes to a loud black man, clearly mentally ill, causing discomfort on the train. That's not the standard for charging someone with a crime. It's not the standard under the penal law of self-defense. There was no indication that Mr. Neely was doing anything that put anyone on the train, including the Marine, in risk of harm.
Let's talk about the Marine statement through his lawyer saying that he could not have foreseen his death. The client never intended to harm Mr. Neely. You see the statement on your screen right there. On the flip side of this, he has over 40 prior arrests. People said that they were scared on that subway car. What is your reaction to this statement that is being put out?
Well, first of all, no one on the train knew anything about Mr. Neely and his background, other than maybe they've seen him in the past performing as Michael Jackson. They knew in the minute that he was indicating that he was hungry, he was thirsty, he didn't have a home, he'd rather go to jail. This was a man in crisis who was articulating, lack of basic needs that this city should be providing to him. So you end up with a situation, by all reports, that should never have happened. There was no risk, and you have someone who took it upon themselves, a Marine, trained in chokeholds, to deploy deadly force to take down a combatant. That is what I saw on the video. And for his attorney now to have put out a statement that places his client's actions clearly within the scope of the penal law in New York State that speaks to use of deadly force by a civilian. We are not Florida. We are not a stand your ground state. And what we're seeing in the statement is a clear defensive position by a defense attorney to cloak his client with a defense. It's all playing out in the court of public opinion. The investigation is ongoing.
So, Jeremy, you've dealt with grand juries before, so I know it's hard to get into the minds of what certain people can be thinking, but let's go over some of the things that they could be thinking about before they decide whether or not to bring about charges. What will they be looking at? What are some of the things that they can be considering?
So we can't keep our realm solely to that video. There's witnesses, meaning people on that subway, strap hangers, riders, who are going to tell you whether or not they were scared, what actions Neely had. It's not just his words, but did he confront anyone, for example, get in someone's face? Did he get aggressive and throw things down? I don't know. I'm just throwing some sort of ideas out there because to the point you just made before, the justification or to have an action where you hold someone and you ultimately choke them, was there an imminent harm, an imminent risk of danger to people, either that individual, Mr. Penny, or someone else that caused him to react? So they're going to want to listen to 911 calls potentially, assuming that there's some excited utterance from witnesses directly from that video. And potentially, Penny could go before that grand jury and exercise his right to testify if it gets to that point.
We keep hearing this term or seeing it splashed over the papers, vigilante. Are there any protections, depending on what he says and what his lawyer says? What do we take from that word? I mean, are there fears as well, Beth, that people might mimic what they saw there?
Of course. I mean, we're seeing this across the country with people taking the law into their own hands, to take aggressive action against people who are unhoused, people with mental illness. We see it in San Francisco, and now we're seeing it in New York State. This is unjustified action, and what has been put out into the public domain already, and we've already had a trial. Mr. Neely has been convicted. He got what he deserved. He is a black, angry man who clearly must have been aggressive. We've heard the drumbeat from Hochul and Adams since February of 2022. Subways are a dangerous place. We have too many men of color who are mentally ill aggressing in the subways. They need to be removed. The city sweeps, the city puts in the police. All of this has been tried in the public domain, and the fear here is that if there is not an investigation, if there are not criminal charges, a process through the criminal justice system to give some sort of recourse and justice to Mr. Neely and his family and to others who are similarly situated. This city and state have failed people like Mr. Neely. When I saw the reporting on his touches with the criminal justice system and the failure to provide services and supports to him, it's a complete failure of this system.
Real quickly, any hope that this will be a learning moment, a teaching moment to better the system? I mean, we've had so many moments where we could have done better. Is this the moment?
This should be the clarion call for us to stand up and consider, who are we as a city, as a state? We have a state constitutional provision. State and the city are required to provide care for the needy, including the mentally ill. And it is expensive. There is a mismatch in the timeline between ramping up services that have been missing for 40 years and actually addressing situations that might create public safety, that creates danger for people like Mr. Neely.
Jeremy, just last couple seconds, your final word.
There's a presumption of innocence. As much as we all want to rush to judgment and say Mr. Penny is guilty, we all would expect that for ourselves. We all deserve that for ourselves, no matter your color, no matter your religion, no matter your ethnicity. So he is innocent until proven otherwise. And he deserves that right. We should not be trying this case in the public domain. He has a defense, and we'll see what happens. But there is a burden that the prosecution has to prove, and no matter what happens, the result is tragic, no matter what, period.
But Mr. Neely was innocent as well and has a presumption of innocence, and we've already tried and convicted him, and he's dead now. So
We appreciate you both for your time this morning. Thank you
you
so much.
Thank you.
thanks.